Good morning.
Good morning. May it please the Court, Timothy Shine for the Commonwealth.
You may proceed. I'm
Thank
sorry.
you. The case before you today is controlled by Madigan, a case from this court, and it revolves around public policy.
Excuse me, doesn't Madigan say something about aggressive actions? What was aggressive here?
Exactly, Your Honor. There is nothing aggressive in the information provided by the defendant regarding the confidential informant. No aggressive persuasion. There was some indicated by the police department, clearly.
Well, why isn't, since it's entrapment, why doesn't that count?
Well, it counts certainly for the police department, and certainly an entrapment defense is viable at trial.
Yes, but, it would help that defense, and it seems to me one could argue it's material, if not only did the police officer, the undercover police officer, do what he did, but indeed had made an agreement beforehand with the confidential informant to set this up. It seems to me it's another link in the chain of entrapment.
Well, when you say set this up, there would have to be some kind of egregious activity by that CI, meaning more than simply an introduction, which is all that is here.
Why is that so?
Because that's the way the law is regarding entrapment and inducement.
In Madigan, which actually was my case below, the whole issue was about the confidential informant. There was no question about the police officer. That's different here.
Yes, Your Honor. And this focus is still on the confidential informant's activities, no question. However, in Madigan and cases like Diaz as well, the level of activity is more than what is present in this particular case, Your Honor.
Well, not if you consider them together and you look at what the police officer was doing. It seems to me, I don't see how you can quite split off the confidential informant that way.
I humbly disagree, because it is simply an introduction here. There is an introduction and there is one request.
It's not simply an introduction. It may not be the fullest affidavit, but she said the defendant says that the possible informant continually told me she had someone she wanted me to meet. I told her I had health issues, didn't want to get involved. She called me again and urged me to consider. Finally agreed to do so.
That's correct, Your Honor. And with regard to that, there has to be some showing of criminal activity. I can ask anybody to meet me or to spend time with me, but I'm certainly not asking them to sell me drugs or to
introduce me. Well, if you've got two undercover agents, right? If you have two undercover agents, right? One is Lion, one may be this other person, and one of them says, I'll get her in, and then this one, gives me the drugs.
And that's allowed under the case law. We have seen historically that police are allowed to do that. That's their job. It's when they go beyond that that it is unfair. When they go beyond that, meaning they implant the seeds of corruption, of crime into the...
But on that theory, you would say he doesn't have an entrapment defense even with the police officer, right?
Oh, I disagree.
Well,
assuming what he describes in the affidavit is accurate, if I were a judge, I would give the entrapment instruction at trial.
This is just the tail of it, or the head of it. I just don't see how you disconnect the two.
It's disconnected because Madigan brought entrapment into the pretrial stage, which it never was before, and the case law supports that. Through Schumann, Madigan cites as bringing it into that area or that arena, but never before was that held. And I would suggest that due process is less in the pretrial area. For example, at a motion to suppress hearing, you're allowed to introduce items that would never be allowed at trial.
Yeah,
so it's that change.
But this isn't a motion to suppress.
No, but it is a pretrial motion for discovery, Your Honor, which is different.
No, well, if you want to dismiss the indictment, correct?
No, there's been no motion to dismiss. This is simply a discovery.
No, but if you want to, if the defense is entrapment and you want to move beforehand, before trial...
Well, that's not the case here. That was the case in Schumann, Your Honor, and that's the case which Madigan cites to it is triggering that. However, in Schumann, that was never even revived at trial. Entrapment was never even brought up.
Mr. Shine, nothing's going to change now versus trial with respect to the argument that this is a connected link of the entrapment defense. So
a connected link, but that's the claim. But the actuality is it's a mere introduction. And I think you cannot overlook that, Your Honor.
Well, Mr. Schein, let's just assume that the person in question was indeed paid by the Commonwealth to do what, is it a she or he? I forget.
She.
What she did. Doesn't that help the entrapment defense?
No, Your Honor, and I would say yes if the facts were different. But the facts in this particular case are a mere introduction and then a request for a narcotic. And the case law supports that argument. It's got to be more than just mere introduction or solicitation. There has to be more. Even Madigan stands for that, because of the information that Madigan points to is aggressive.
Would you agree with me that if Ryan, the undercover, if he had called her up, he got her name, right? Called her up and continually asked her out for a date, whatever the affidavit says the other person did, continually asked her out for a date. And she said, no, I've got health problems, I don't want to get involved. And he called her again and urged me to reconsider meeting him, and she finally agreed to do so. And then he requested a painkiller to ease his back pain. She said, why don't you go ask your former girlfriend? I'm reading down the affidavit. And he said, please, I can't, give it to me today. Then he called her a second time and said, I can't reach her. No question that if the defendant asked to identify this person as an undercover police officer, we would look at all of those circumstances, correct?
No, Your Honor. The mere introduction portion of it, the meeting up, that's part of active police work. That's what is done day in and day out.
You would not look at that, you're saying. You would say to determine whether or not discovery should be provided, one would look only at the set of circumstances that begin when he says, please give me a painkiller.
Precisely, because that's the request for the criminal activity. That has to be the beginning, the inception.
What about the, I'll call it vouching for the undercover police officer by the CI? Doesn't that change the analysis somewhat from a mere introduction to an introduction plus he's a good guy, he's trustworthy, and he's my friend?
I agree, Your Honor, if the facts were such where they said just that, and he's got great drugs, he needs some drugs, he's got some drugs, there's some type of criminal activity here. And that was never said. That was never done, never demonstrated by the defense.
Well, it seems to me that going back to what you said in the beginning, using Madigan as the basis, Madigan says the types of conduct that possess the indicia of inducement include, quote, aggressive persuasion, coercive encouragement, lengthy negotiations, pleading or arguing with the defendant, repeated or persistent solicitation, persuasion, importuning, and playing on sympathy or other emotion, unquote. And at least I don't see any of those factors present in this case.
I tend to agree with you, Your Honor. The factors that are focused upon are exactly those, and that is stemming from Madigan.
But that's if you totally divorce the CI from the police officer.
Well, if the CI we're focusing on strictly the CI, if the CI possessed exactly that, if she said, come on, you've got to meet this guy, you've got to do this, I need a fix, I need something, and there's criminal activity involved. That's where the distinction is made, Your Honor.
Wasn't there some cajoling by by the confidential informant to get the defendant to give certain prescriptive drugs to the police officer? She said, if you give it to him, I'll replace it for you later. I mean, she was a participant in the request by the police officer.
That's an important distinction to be made as well. She was a participant in uncharged criminal activity here. This case involving where the CI was involved is not charged. She was the introduction. There were 3 more buys done strictly with the person, Ryan, who was the undercover officer, and the defendant.
Do you agree that in that first situation in which there was no charge, there could have been a charge?
There could have been.
That there was sufficient criminal conduct for a charge?
Certainly, Your Honor. But typically speaking, just as there are in search warrant affidavits, when they're generating the probable cause, the CI would then be exposed, or would have the potential because she is a witness.
So by not charging, by electively not charging the defendant for that first sale, I take it your position is the Commonwealth has effectively written entrapment out of this whole equation.
Well, to a degree. It's the same situation with regard to search warrant affidavits. When you have a control buy, when you send a confidential informant into a complex to make a control buy, those purchases are not charged because they are a portion of the search warrant that eventually leads to the warrant going into the home that leads to the charges.
Yeah, but what you're doing here is you're saying that by not charging her for the first offense, you're able to separate, you're able to manufacture a divide between the relationship of the confidential informant and the police.
I understand your question, Your Honor. Yes, and if the facts were different, meaning if this particular CI said, I need a fix, you need to help me out, this guy, you need to sell this guy drugs, and then we chose, as you described, to avoid that, we would be effectively cleansing that out. And I think the defense would have more of an opportunity to examine that type of behavior. But those aren't the facts here, Your Honor. I agree with you. But they're not the facts here in this particular case.
Well, with the entrapment, if the Commonwealth had charged the defendant with the first purchase through the confidential informant, would the entrapment defense apply to the first or to the second purchase?
The entrapment defense, well, it would be the scenario would be different because if we did charge in that particular first instance, he or she would be the only non-governmental witness. And I think there is more compelling showing to say that, well, there's charged criminal activity here. She is the only non-governmental witness that was present, and she's a precipient witness, which typically speaking throughout CI cases has been intended. The court has tended more so towards revealing a CI where she is a precipient witness.
Also,
But wouldn't an entrapment defense apply?
Correct.
Wouldn't an entrapment defense apply to the second purchase as well?
Yes, well, certainly. This entrapment defense, whether the CI is revealed or not, is very viable if this case were to proceed to trial. Absolutely, I agree. And I think if I were a judge...
Based on the defendant's interactions with Officer Lyon.
And based on what is claimed, Your Honor. Certainly...
Sure, so you're saying she's got an entrapment defense as to Lyon.
Yes, Your Honor. Yes, certainly the entrapment defense is viable and it is available to the defendant even if the CI is not revealed. And if you were to give credence to the defendant's affidavit, if I were a judge, I would certainly, after hearing that portion of evidence, allow an entrapment instruction.
Mr. Shine, let me try an inarticulate closing argument to the jury. Members of the jury, my client had never met this undercover agent, had no interest in him, as far as I can tell, had never given these drugs to anybody else. There's no evidence of that. What happened was undercover agent A repeatedly asked her to meet undercover agent B. Undercover agent B, the first time around, undercover agent A said, just give him, the one pill, I'll repay you for my stack. The next time, undercover agent B said, I can't get hold of undercover agent A. That's one scenario. Second argument is a woman known to my client introduced her to undercover agent B. So you take out the whole first offense. Don't you think it weakens the defendant's argument to say, well, this was just a friend who introduced her to an undercover agent?
That's the claim. That's the Commonwealth's claim, Your Honor. It's in mere introduction, looking at the case law is allowed. That's what police do. They fight crime. They need to set these things up. This is illicit, covert activity. They need to set these things up somehow. But what Madigan stands for is they cannot implant the seeds of crime in innocent people.
Let me just follow up on those questions I was asking you before. Am I correct in understanding your position that the confidential informant may have softened him up a little bit for purposes of the first sale, but by the time the second sale rolled around, the predisposition to sell was there, and the entrapment doesn't work. You can't. The defendant is not entitled to piggyback the confidential informant's involvement in the first sale onto the second.
I agree, Your Honor. And also beyond that focus is, was she predisposed, she being the defendant, was she predisposed prior to even the introduction? And that's what entrapment is all about. If entrapment does make it to trial, the Commonwealth is allowed to show and rebut any of that claim, and that would be by showing and demonstrating her previous criminal activity.
Sure, but that doesn't help us answer this question.
Well, the case law should, Your Honor. Thank you.
Thank you, Mr. Shine. Good morning, Mr. Lewins.
Morning. Chief Justice, ladies and gentlemen of the panel. I'm happy for a change to have a red brief. That doesn't happen very often.
But it's not unique.
No. What we have here is a failure of the Commonwealth to look at the totality of circumstances. That was the point made by the trial court judge, that by looking at the totality of circumstances. And as some of the questions have pointed out, how do you separate it out? We're drawing too fine a point. Not only did the confidential informant, and there's no dispute this was a confidential informant, get my client down to where the transaction took place, but she participated in the transaction. It's a much stronger case than Madigan. She actually participated in the transaction.
But what do you say to the Commonwealth or Justice Spina that since that transaction itself wasn't charged, doesn't matter?
Oh, well, they very carefully didn't charge. In fact, they told us nothing about it. Based on what my client said, I had to move for the police report, which you see there. And, of course, we know why they didn't do it, because there'd be no question that they would have to turn over.
But I take it what you're saying is we have to look at both of those. If there is a relationship between the confidential informant and the police officer, we have to look at how that relationship worked itself out on the defendant, so that if the confidential informant softened him up for a subsequent sale, the Commonwealth doesn't get the benefit of the predisposition that developed later.
I love that word, softened up. We know there's a confidential informant involved in this. You know, there's no question about that. So we're to first base. And one thing that was pointed out, or wasn't pointed out to the single justice, was that there was a lot more to that affidavit. His argument to the single justice was only based on the affidavit up to the point of the first sale. But the affidavit talked about solicitation, strong playing on sympathy, pleading, arguing, persistent solicitation.
That was by the police officer, Ryan.
Exactly.
And he's known, but he's not, I mean, you know now who he is.
Well, it's not a question of the police officer. This shows that there was inducement, and the only question, there was strong inducement by the police. The only question is the tie-in, whether we can separate out the fact she participated in the first sale, that she got him down there. And as Chief Justice Marshall pointed out, that strengthens the argument tremendously, rather than simply saying, he came down, and the first time anything happened, or she came down, she sold me drugs. If you can show prior to that an effort to get the ball rolling, then it's certainly valuable. And one thing we have to remember
I
here...
guess the question is whether you have to show that there was, quote, inducement by the first person, or whether the actions of both people together can be considered.
Yes,
That's
you
really
can.
the whole- that's the question.
That's the issue. Can you consider both of them together?
Right.
And
Because do you concede that the actions of the first person alone do not equal inducement?
No, I don't concede that at all, because you have inducement at the first incident that was not charged and not even turned over to us. She was in a position where the guy says, I've got to...
And is give him the pill, he really needs it?
Yeah, he says, I have a bad back. And
Not at the first one.
I
He said,
It was later.
No, even then, I think, that was his
In
reason.
the first one, wasn't the CI the one who persuaded, or it is alleged, persuaded your client to give the
Right.
the single pill? Or
Right. In other words, the officer, undercover officer, he said, "Oh, I need a pill, my back hurts, I believe, or something." And he said that to the confidential informant. And the confidential informant said, "I don't have a pill," and turns to my client and says, "Oh, can you help out now? Do you have a pill?"
Well, you're adding a lot to the affidavit. I mean, you're fleshing it out nicely, but the affidavit just says at the first meeting, Ryan, who's known, requested a painkiller to ease his back pain.
Right.
Kristen, who's unknown, said she didn't have any and asked if I would give him one, which I did. So all this other information that you've just given us isn't in the affidavit.
I didn't give any more
Well,
information
you
with
said
all
there's all this,
due
oh,
deference.
you just said this, oh, it's killing me, give me something.
Well,
That isn't, but that's
painkiller.
not in the affidavit.
Well, I don't have it in front of me, but he talked
Okay.
about
But the affidavit
pain.
is quite bland if you go as to that. All she said was she didn't have any, would you give him one? And I don't see that as pleading,
Mm.
begging, sympathy. That's really, I don't have one, you give him one.
But the law is you only need some
but-
evidence, some. It can be
But is that
unsubstantial.
solicitation? I mean,
Well, sure it is. As Justice Marshall, Chief Justice Marshall pointed out, it strengthens the argument. The heavyweight solicitation took place later, but it was set up by the confidential informant. And the standard is very, very low in this case. We have a much stronger case than Madigan. In that affidavit, the specifics, we have the dates that the Madigan case didn't have. We have the name of the CI. We have what was said to her and what was responded. The affidavit is much stronger than Madigan. And on reading Madigan, I realized it had to be stronger, and I made it stronger.
Mr. Loans, let me ask you this, and maybe it's just a new year and I'm not quite recovered from the holiday season. We know the name, because it's in your client's affidavit, of the acquaintance, and you're constantly saying, we know that she's a confidential informant, and your request is to compel the Commonwealth to reveal the name of the informant. And so is the piece that's missing any and all promises, rewards, or inducements made to the informant?
Yeah, that's crucial.
No, I understand that. But so you know that this is an informant?
Well, we think she is.
But
Okay,
you
well,
don't
But
know
he
it officially.
concedes it. The prosecution concedes it, basically, in his brief.
But you don't-
I
You don't know whether there are any rewards, inducements, promises.
And we don't know what she's going to
deals.
say. She may deny being an
an informant. I just want to be clear, because once or twice you'd said, we know she's an informant. I don't think the Commonwealth has conceded that. So you need both to know whether she's an informant and B, whether she's had promises, rewards, or inducements, correct?
Yes.
Okay.
So, in the case of the key case, Madigan case, and he cites that as the basis for his argument. Well, fine. I'm citing it as the basis for my argument, so it's a matter of interpretation, of course.
May I ask you this question, which is somewhat responsive to Mr. Shine's argument? The facts in this case, when she first introduced your client to Officer Ryan, there was a transaction at which Kristen Gross introduced her. I mean, there was a transaction, the one that Justice Cowan referred to. My back, give him one, I don't
Right.
have one, so on. Let us assume that there had been no transaction and that the acquaintance of your client said, I just want you to meet this guy. And that was the only thing that she did. Yes, she did it repeatedly, continuously. Please go and meet him. You will like him. you've really got to get over, whatever it is. It'll do you good. I've known him, go and meet him. But that's all.
That would be enough. It wouldn't be quite a strong case.
You think?
But it would be the overall circumstances. It would make the argument stronger that she brought him in contact with the undercover agent by inducements.
Well, there are no inducements.
Well, continually saying, come
Okay.
down. So the issue there is isolate that completely and say, just because they didn't say come down for a drug deal, then you don't have any argument.
Think of
But
another.
that's not our case.
So the two women are sitting at a bar or in a public park or someplace, perfectly legally, and the first woman, not your client, knows the police officer, or says she does. He comes over and says, "Hi, Kristen, great to see you," and she says, "This is my friend, Crystal Mello." That's it.
And then
Some later time he calls.
she puts him in touch with the police officer.
Oh, no, he just comes over and says hello. And then later he calls and says, remember me, I came over to say hello to you. I mean, in other words, nothing transpired. No inducement, no repeatedly, no nothing.
You mean no introduction at all by the...
Well, he comes over, the
Yeah.
two of them are sitting at a bar, and she says, this is my friend, Crystal Mello, and he says, "Hi, great to meet you.
And then she's out of the picture.
She's out of the picture."
Well, that would be a difficult case for us.
Okay.
I agree.
Mr. Hurons, I hadn't focused on this when I read the briefs, but let me ask you for your take on the law of entrapment. If there are a series of sales of one pill, one illegally possessed pill, for, let's say, 3 or 4 sales, and the first sale is brought about as a result of entrapment, and then the 6th sale, the police say, well, I don't want 1 pill anymore, now I want 10,000, and the defendant sells 10,000 pills. Is the entrapment defense good for the sales of the 1 pill but not the 10,000 pills? Is that the way it works?
No, it's good for...
The 10,000 pills also?
Sure.
I mean, once entrapped, you're there for, you're entrapped throughout? 3 years later, you're still entrapped?
Well, did you say 3 years later?
No, a short period of time.
No. Once again, you have to look at the overall situation. Now, one point that is clear is that the prosecutor has conceded, in oral argument, conceded that she was the confidential informant. And in his brief, he does, I believe. Or at least he concedes there was a confidential informant. That person who got her to come down is a confidential informant. He might not have conceded who it is. So it's not like, she wasn't a confidential informant, and she just happened to
Yes, but
bring him down because I was saying I wanted to meet her. And she didn't know why he wanted to meet her. And she just brought him down. That would be a different story.
yes, but you would have, the fact of being a confidential informant by itself doesn't matter.
No.
What matters, I think it's correct. It's what matters, because then any controlled by becomes discoverable as to who the confidential
I
informant is.
agree. And the district attorney tries to equate the two. He's argued several times that that's the law, that if someone goes in and buys drugs and then tells the police that he bought drugs, they go in with a motion to suppress. That doesn't go to guilt or innocence. We're talking about guilt or innocence. So that's a very different situation from simply a motion to suppress or discovery or anything along that line.
Mr. Lawrence, I just checked the Commonwealth's brief, and I apologize, it's not Officer Lyon, it's Officer Lyon Maltese, of course. It says, first, on an undisclosed date in December, Officer Lyon Maltese conducted a controlled buy of OxyContin from the defendant in Lakeville using a confidential informant. Are you saying that that is the same episode as the one in your client's affidavit?
Yes.
But wasn't it a gift? In other words, there wasn't really a buy, was there? The one that you're talking about?
Well, it's a crime.
No,
It
no.
doesn't have to be a buy.
Okay,
So,
all right, I see. Just there was a transfer.
yeah, it was a transfer. And you have Ryan, the affidavit saying Ryan begged me to get the drugs. So there's no question about serious solicitation from the police officers. So the question, of course, is the tie-in. Can you just separate out everything that went before that and the role she played in bringing my client down and actually participating in the first incident? And of course, they realized they had a real problem. So they wanted to forget about that first incident and not even bring it up and not even turn it over in discovery.
Mr. Learns, your time is up, and I should have asked Mr. Shine this, but the facts as they laid out in the Commonwealth's brief, which is somewhat different from the facts in your client's affidavit, where do those facts come from?
That's a good question. He doesn't cite anything.
Okay. Thank you, Mr. Learns.